No, no surprise at all. It's a mandatory sentence, but the only thing that has any degree of discretion to it is eligibility for parole. And what should be obvious to everyone is that the parole board is the body that makes the decision. They can look at recommendations, but they're not bound by recommendations. So the jury, the judge, the prosecutor, and the defense all said minimum eligibility 10 years, which is the lowest level you can get to be eligible. And hopefully the parole board will see it as that as well.
The judge was asking about Mr. Cowan's medications, and you had requested that he be put into protective custody. Reasons for that?
Well, because he has a catastrophic brain injury, he requires almost 24/7 supervision and help. He's been in assisted care living. He's been living with aunts who know his particular set of circumstances, and with his aunts, they make sure he takes his medication, they make sure that he's safe, they make sure that he eats 3 meals a day. That's the kind of thing that the jail facility is going to have to take care of, and we just wanted them to know that the judge and the prosecutor and myself were all in agreement that he should be in that protective custody, that nobody else gets at him and can hurt him, and that he's allowed to have his medication and to eat properly.
Will that help him in getting earlier parole, do you think?
I think it will. I believe that he will get parole at the earliest eligibility. I'm even so hopeful that this case gets overturned on appeal. I expect that he will be released pending appeal because he has lived on bail conditions that are quite strict for 3 years without any breaches, and since the date of the verdict, which is a couple of months ago, with no breaches of conditions. So he has gone better than 3 years on strict conditions, never a breach, never even an allegation of breach. I think that all holds him in good stead.
As to the appeal, that is in motion. When will that be served?
It'll probably be served by December 21st. James Lockyer, a person that I use regularly on appeals. I don't argue my own appeals. I always send it to another lawyer. Always good to have another set of eyes look at what happened. And James Lockyer, who's a brilliant appellate lawyer, he is the president of the Wrongfully Convicted Association, as most of you probably know. And I arranged this with him probably a month ago and said, we'd like you to do the appeal if you will. He's quite willing to do it. He's anxious to do the case. So any further questions related to the appeal, he's probably the guy you should talk to.
But Mr. Cowan will be in custody in the period between now and when that paperwork goes through?
Yeah, they need to put the paperwork in. It's with the consent of this prosecutor. So I expect that with no breaches and the prosecutor consenting, Mr. Carnegie has taken over now, and he's a very senior prosecutor in the province at the highest level of the organizational chart. If he says he's consenting, and he's told me I could tell James Lockyer that, and I have told him that, I think probably he'll be out on bail and he'll await his appeal.
Mr. Cowan's one statement to the court was that he was not guilty. Clearly,
right.
That's still his position.
Absolutely, it's his position. It's what he said from day one. And one of the difficulties that I had with the trial is that I knew that he couldn't testify because of the evidence that I had from neuropsychologists and neurosurgeons that said his brain injury is so catastrophic that he mixes up things. If you ask him a question, he can't always follow the words, and he sometimes answers with information other people have given to him, thinking mistakenly it's his memory, when he really doesn't have memory, and the experts tell me he's not capable of having memory. That's how catastrophic.